The special counsel wrote, and I quote, "Several material distinctions between Mr. Trump's case and Mr. Biden's are clear."
Okay, we're going to stop you right there, Mr. President. The only thing clear is that you are not okay. While he may be getting off scot-free for keeping classified documents, even the special counsel can't cover for his memory lapses.
In the report from Robert Hur, it says, quote, "Several facts would make it difficult for the government to present a case that reasonable jurors would unanimously find compelling. Mr. Biden will likely present himself to the jury, as he did during his interview with our office, as a sympathetic, well-meaning elderly man with a poor memory. While he is and must be accountable for his actions, he is, after all, the President of the United States. Based on our direct observations of him, Mr. Biden is someone for whom many jurors will want to search for reasonable doubt."
Sure they will. All right, let's bring in former Acting Attorney General Matthew Whitaker. Matthew, good to see you. We appreciate you joining us. Obviously, this report talks about Joe Biden's cognitive decline, but just want to get your reaction to Hur's decision and the report that he released.
Yeah, well, hello, Dagan and Sean. You know, it's pretty stark if you think about it. The differences are actually to the advantage of President Trump. He was president. He could have declassified the information he had. He had the ability under the Presidential Records Act to possess certain pieces and parts of this, if not all of them. And Joe Biden was either a vice president or a senator, and he willfully retained this classified information inconsistent with the law. I mean, the report says he committed crimes. They just don't want to bring it to a jury because they don't think they could win the case. And I think that is probably the most consequential judgment of a prosecutor that we can see. And this reminds me of when Jim Comey gave Hillary Clinton a pass on her email server as well. And it just puts a very bright light on the two-tiered system of justice that only seems to go after President Trump for the slightest infraction that they want to.
The case is laid out in the documents, Matt. As the Espionage Act statute reads, it's just gross negligence. This is gross negligence, whether the man is a doddering old fool or not. It's just an abomination. But we really want to move on to what happened today at the Supreme Court. The High Court hearing arguments in the Colorado case today that could keep President Trump off the ballot. And Colorado's lawyers even have liberal Justice Elena Kagan sounding skeptical.
Question of whether a former president is disqualified for insurrection to be president again is, you know, just say it. It sounds awfully national to me. So whatever means there are to enforce it would suggest that they have to be federal national means.
No, Your Honor, because ultimately it's this court that's going to decide that question of federal constitutional eligibility and settle the issue for the nation.
Colorado is just one of several other states that have similar challenges to Trump's ballot eligibility. So, Matthew, again, it sounds like the Supreme Court is sounding like they're leaning towards Trump's perspective, and this is a federal issue, not a state issue. What was your perspective?
Yeah, Sean, I think it also shows you the difference between politics and political, talking points and actually the law. And, if you look at, people that are, all, qualified to sit on the highest court, accomplished lawyers in their own right, they all were very skeptical of what Colorado had done, what the standard was, what the process was, even the most liberal justices. I think you're going to see this court, and I think one of the reasons for their questioning was they were trying to convince their colleagues that where a unanimous court could speak on this, because as you know, this is a very specious idea of, Colorado and even the Secretary of State in Maine to take Donald Trump off the ballot, according to, how they did it in the process which they employed.
One thing that stood out, Matt, and to quote Andy McCarthy, when we talk about the liberal justices, it's not the politics of it, it's the judicial philosophy, and they are progressive in that way. And even listening to Justice Ketanji Brown Jackson, when they talk about the 14th Amendment handed power to the federal government and took it away from the states in essence. So this is kind of a touchstone for progressives. And that was one of the reasons, and it's very important to progressive justices. So it might be the very reason you get a 9-0 decision in favor of President Trump, that this is not up to the states to make this decision.
And unlike, the progressive Democrat wing of the Democrat Party, which includes most of them right now, I think the Supreme Court justices on both sides see how this could be abused if the shoe is on the other foot. I mean, you saw Samuel Alito lay out a very interesting hypothetical question about other parts of the Constitution and those being applied to, for example, Joe Biden by a red state. And so I think that, thankfully, the law does have meaning. This is a country that follows the rule of law, and the Supreme Court seems to be the only rational voice right now in a real dark, hyper-political world.
A country of laws followed by the Supreme Court, maybe. We're not so sure about the Attorney General's office. Matthew Whitaker, always a pleasure to see you. Thank you for joining us. We appreciate it.
Good to see you both. Thank you.